There was confirmation from the Presidency yesterday that President Cyril Ramaphosa has suspended the Western Cape Judge President, Judge Hlophe. That came after the Judicial Service Commission made a formal recommendation back in August that he suspend Hlope following the Judicial Conduct Tribunal findings against him. Hlope was found to have tried to interfere with constitutional court cases involving former President Jacob Zuma back in 2008. Advocate Jeremy Gauntlett is both a senior counsel and a King's counsel. He's also a director for the organisation Freedom Under Law. Jeremy, good afternoon to you. You're welcoming this decision by the President. Why do you believe it's the right thing to do?
Well, it follows, as you've indicated, after a 14-year delay, which is truly shocking. 14 years ago, these events took place. The Judicial Service Commission itself, in its former setup, delayed, most of us believe inexcusably, for those years. The Judge President, embattled as he was, sought by every means to delay and to challenge the proceedings. It's culminated in the following. One, a finding of misconduct such as would warrant impeachment. Two, its own recommendation that there be a suspension. Unfortunately, the President himself has taken nearly 5 months to decide on suspension, and as you know, has announced his decision in between the outcome of the debate and the occurrence of the conference. Others may draw their own inferences. But the bottom line is, at last, it's happened.
So you believe the President could have acted earlier. Do you believe that he should have acted earlier?
Yes, because if you have a situation where you have the head of any public institution facing very serious misconduct charges, and an independent body such as the Judicial Service Commission, however belatedly, comes to the conclusion that there's such a case to be met and recommends suspension, it's serious. Because every day, in the case of a head of a court, he sits on cases, he takes decisions, and he's involved, as Judge Hlophe did, involved in the proceedings of the JSC itself, choosing the next generation of judges. So it was inherently urgent. Many have drawn an analogy with the position of the delay regarding the public protector. I leave that to one side. The crucial situation is that for the first time in the history of this country, you have the head of a court who stands to be impeached, and one would have hoped that the suspension would have happened sooner. That said, one welcomes the fact that it has now happened.
As I understand it, Judge Hlophe is challenging the advice given by the Judicial Service Commission in court. In other words, he's saying that the Judicial Service Commission should not have given this recommendation to the President. Does that mean that the President may have been too hasty, that he's acted too early, he should have waited for that?
No. I think, and certainly it's the position of Freedom Under Law, that the body of material was overwhelming. There was nothing hasty about it, quite the contrary, as events have shown. And may I say again, it is backed by the fact that independent bodies such as the JSC, not just the President, but the JSC, first of all through a Judicial Conduct Committee, then through a Judicial Conduct Tribunal headed by the judge, then the plenary JSC held that there was on the face of it this misconduct, and secondly, that he should not be sitting while this situation continues.
In the meantime, it seems to me quite likely that Judge Hlophe may well challenge the President's decision. If he does that, he's likely to argue, or his attorneys may argue on his behalf, that he should be allowed to remain sitting as a judge on the Western Cape bench. And it seems to me that that could be the fight, that there could be a huge argument about whether he's actually allowed to do that while his application to challenge the suspension is being heard. Isn't it likely that he could win that fight?
I would not think that it's likely. That he is likely to bring that fight, I would have thought, is unfortunately proven by the previous conduct of what has been called for a long time now lawfare. And that is effectively sand in the gearbox, or an attempt to introduce it. But the position is simply that the President has spoken on the advice of the top body. It is a suspension. It is effectively garden leave. And in the circumstances, one would hope that a court would not interfere with that. Of course, the piquancy is the fact that the proceeding is likely to be brought in the Western Cape High Court. And one would hope that there would be no unfortunate work at the crossroads as regards the allocating of a judge to hear it, and that if such an application is brought, and that it would be dealt with as it should be on its merits.
The end result of this entire process is that it has to go to Parliament. Parliament eventually makes a decision on whether or not to impeach a judge. And the idea is that impeaching a judge should be, and it's deliberately made difficult within the Constitution. Judges Matter, another NGO, has suggested that that process is likely to take a long time, may or may not, but that's actually a good thing, that it should take a long time because it should be difficult to impeach a judge. Do you agree?
No, I think it should be a very careful and considered procedure. But as it's been said, riding a bicycle does not get safer to go more slowly. There has to be a certain due deliberate speed, as the Americans would like to put it. You have a situation where you're balancing two things. One is fairness as regards the individual concerned, but the second is the fact that you have a head of court which, on the face of it, for 14 years should not have been sitting there, who faces other allegations of misconduct, including by his own deputy. And one would hope that in the circumstances, a Parliament would say that this is a matter which requires reasonable expedition.
Thank you very much indeed. Advocate Jeremy Gauntlett is a director at the organisation Freedom Under Law.